This lecture series is part of the Law, Politics, and Media course, a course that's cross-listed between the College of Law, Maxwell, and Newhouse, and co-taught by myself, Keith Bybee, Lisa Dolak, right there, and my spiritual advisor, Roy Gutterman, to the right. This speaker series is co-sponsored by the Institute for the Study of Judiciary, Politics, and Media and the Tully Free Speech Center. We bring out practitioners from the bench, the bar, the world of policymaking to discuss issues at the intersection of law, politics, media, broadly understood. And today we're very fortunate to have Thomas Spahn, who's partner at McGuire Woods. The title of his talk today is Lawyers, Judges, Ethical Rules, and Limits on Speech. Mr. Spahn has practiced as a commercial litigator with McGuire Woods since 1977. He regularly advises Fortune 500 companies on properly creating and preserving attorney-client privilege when conducting corporate investigations, when hiring outside consultants, when dealing with the government, and basically when doing anything, either ordinary or extraordinary. He's assisted in creating and defending privilege logs in many product liability and commercial litigation matters. He also advises a number of practitioners, including in-house counsel on ethics issues, including conflict of interest and confidentiality. He is an expert of many years with familiarity in advising with all things ethical. All things ethical. Well, really, just legal ethics, which I think he'll explain are somewhat different than ordinary ethics. He is a magna cum laude graduate from Yale University and received his JD at the Yale Law School. Before I turn over the podium to Mr. Spahn, just a brief word about how we proceed with these lectures. We will go until 5 o'clock. Mr. Spahn's plan is to engage in an interactive conversation with you. So we'll keep that going right until 5, and then we will have a reception right in this room. And I encourage everyone to stay for food and for drink and for continued conversation once the reception begins. Without further ado, please join me in welcoming Mr. Thomas Spahn.
Thank you, Keith. And thanks for the water. I promise to maintain eye contact if I reach for the water. Okay. Thanks, Professor Dolak, for inviting me here, and Professors McNeil and Arnold. I taught both of their classes the last 2 days, which was great fun for me. And Nick Everett, thank you for your help. Nick's going to be a trust and estates lawyer, and it's lucky that it's raining, because otherwise his daily golf outing would be interfering with this. It's a real honor to be here. I grew up in Rochester, New York, West Arundequite, and many of my friends and family went to Syracuse. My brother graduated from law school here. And it was fun to come back, although I have to tell you it was weird, because I noticed this bright, shiny thing in the sky yesterday, and I had never seen that in Rochester in the winter months, and it's gone today, so I feel much more at home here. And we're just talking about Joanne Alper, as one of my all-time favorite lawyers, even before she went on the bench, and she's actually everybody's favorite lawyer in Northern Virginia. And she is such a vigorous defender of the law school. Years ago, when we worked together on an appeal, she was raving about the law school, and that would have been in the 90s. So she's as good an ambassador as you can get. And it's a special treat to be here for the Law and Media Center. I don't think there's any other university in the country that has this trifecta of the law school, the Maxwell School, and the Newhouse School. So I'm hoping that there's non-lawyers here. I mean, not law students. Let me ask a demographic question. How many law students have we got here? Oh, lots of crawling with lawyers. Okay. And how many Maxwell folks? Good. Okay. And then how many Newhouse folks? Oh, great. Okay, good. Already good. There's always been a connection between the law and the media, and I think people. How many of you knew that S.I. Newhouse himself was a lawyer? It's amazing. Only 2 of you did. Yeah, he started work in a law firm as basically an office manager type. And then he became a lawyer, went to New Jersey Law School, now part of Rutgers, and he tried one case and probably lost it and decided to go to another profession, which is good for you. But I'm not sure it affected his journalistic career, but the fact that he was a lawyer is not surprising to me, because you can just do about anything as a lawyer. I just saw a story a little while ago that a week from this Saturday is the 8th anniversary of Dan Rather's last night as the anchor on CBS, and I want to mention I spoke one other time at a law media conference at another law school, Washington and Lee Law School. They don't have anything comparable to the Maxwell School there, but it was journalists and lawyers. And the dean of the law school, I think he was dean, Rod Smola of WNL, started the program, which dealt with Dan Rather and what happened to his career when they found out the National Guard documents were fake. And he wanted to get both the journalistic aspects of it and the legal ethics aspects of it, and I was the legal guy. And he said, well, lawyers and journalists do the same thing. They search for the truth. And the journalist kind of nodded, and I had to sort of dissent. What a surprise that is. And I said, that's true, but journalists go about it in a totally different way from lawyers, especially litigators. And I'm a litigator when I get to practice law. And I'm going to start with a couple of questions just to highlight, I think, the difference between how litigators go for the truth and how journalists go for the truth. And I'll take a vote maybe by group. Okay, why don't we do this? So I'll do the lawyers and the non-lawyers. But some of you are joint, aren't you? Did you raise your hand, or are you lying about something? Okay, all right, okay, because I thought I saw your hand go up both times. All right, okay. And that's okay. It means you're going to be a litigator. Does a lawyer who's appearing in court have a duty to give a full and fair presentation of the facts to the judge? In other words, do the lawyers have an ethical duty to give a full and fair description of the factual context of a case? In other words, if there's bad facts that the other side hasn't found, does the lawyer have to give them to the court? So let me first ask the non-lawyers that. How many non-lawyers here think that I, as a litigator, have an ethical duty to give a full and fair presentation of the facts to the court? Yes? How about non-lawyers vote? How about no votes from non-lawyers? Oh, so you know us better than I think. Okay. Why not? Well, let me ask the lawyers. How many lawyers think I've got that ethical duty? Any lawyers think I have that ethical duty? Yes? Okay. There's a medical school here, too, if you want to go to medical school. How about, no, we don't have to be full and fair. All right, the first two people to raise their hands are the ethics professors. Okay. Why not? Why don't lawyers have an ethical duty to give a full and fair presentation? We don't. In fact, the rule, most comments, they're not the New York comments, I don't think, but most comments in the ABA said, we don't have a duty to give a full and fair description. We can't lie to the court, but we don't have to give the bad facts. It's up to the other side to catch them. The other side catches them, good for them. If they don't, good for us. So why don't we have that ethical duty? Yeah?
Well, it's based on an adversarial system.
Mm-hmm. Okay, based on an adversarial system. Let me ask this question. What if I go to court in an ex parte presentation? That is, I want a TRO, a temporary restraining order, and I go in by myself, which is very unusual, but it can happen. If I'm in a court ex parte without the other side there, no other side is there, do I have a duty to give a full and fair description of the facts? Who thinks the answer to that is yes? How about no? Same rule. The answer is yes, you do. If it's ex parte, the New York ethics rules and the ABA say that if in an ex parte proceeding, it's a different kind of proceeding, just like you said. There's no adversarial process taking place, and therefore you do have to give a full, let me read the rule here, I guess that makes sense. Let's see, 3.3D. Let's see here. Okay. In an ex parte proceeding, a lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision whether or not the facts are adverse. And so that tells us a lot about the ethics of lawyers, or the lack of ethics of lawyers. But we are champions for our clients in an adversarial system. We don't have to be fair. And we have to be polite. We should be polite. We can't lie. But we do not have to be complete. We don't have to be transparent. We don't have to be fair in that way. Is it okay for me as a lawyer to offer or use evidence in a case that I reasonably believe is false? Is that ethically permissible? I reasonably think evidence is false. Can I ethically offer or use that evidence? Let me ask for the non-lawyers first. Who thinks it's ethical for me to present that evidence? Yes or no? Yes? How about no, I can't do that? Okay, let me ask the lawyers, or future lawyers, unless I chase you all out of the profession. How many lawyers think I can use it? Who thinks it's ethically permissible for me to do that? Law students. Yes? How about no, I can't do it? Okay. Let me read New York 3.3 comment 8. Well, let me say this. A lawyer shall, this is Rule 3.3, a lawyer shall not knowingly offer evidence offer or use evidence that the lawyer knows to be false. If you go to comment 8, it says this: the prohibition against offering or using false evidence applies only if the lawyer knows that the evidence is false. That's actual knowledge. A lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. Now, I'm not surprised that all of you got that wrong, because...
It's like weapons of mass destruction in Iraq, right?
I'm sorry, what's that?
It's like weapons of mass destruction in Iraq.
The what?
Weapons of mass
Oh.
destruction in Iraq.
Why?
Well, because they were sure that they were there, even though they weren't.
Right, yeah. Well, I'm not sure, I'm not sure how that applies, but if there's knowledge of falsity, if there was knowledge of falsity about the weapons of Iraq and it was a lawyer presentation, that would be wrong. But if you reasonably believe it's false, then it's still ethical to make that presentation. And President Clinton's CIA director said it was a slam dunk that they were there. And so it would be there would probably be a reasonable debate about it. But the fact that it's later proven to be false, I'll read this one too. This is the rule that if you present evidence and you're later found out that it's false, it says this: if the lawyer's client or a witness called by the lawyer is offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. And so if you present something, you think it's true, and you reasonably believe it's false, and it turns out to be false, then you've got to correct it. And that's the duty that we have. So lawyers, the fact that you got the answer wrong according to the rules is not surprising to me, because most of you would not put on evidence that you think is reasonably think is false, because you'll get caught. The other side will catch it, and that's bad tactics. But that's a tactical decision. It's not an ethical decision. And so the fact that we as lawyers can do not have to be full and fair presentation to the court, and we can present evidence that we reasonably believe is false, it tells us a lot about the adversarial system, as you were saying. That's how it works, because we go about finding the truth in an adversarial way. Journalists do not. If I present evidence that I reasonably believe is false, and it turns out to be false, I may have a bad day tactically. Dan Rather put on evidence that was proven to be false, and it destroyed his career. And that's because we expect journalists to be fair. And maybe we shouldn't expect that, but I think that's what the American people do expect. And so, to me, the professions are totally different when it comes to that. So, and that was equally popular at Washington Lee as it is here, I can tell. That's why people call me the Antichrist, as I said when I was in Washington Lee. So, anyway, that's just who we are as lawyers. You may not like it. People don't like it. It doesn't mean we have to be unprofessional or not civil to each other. But we serve a role in society that is inherently adversarial. And so we're going to anger people when we win. We have duties that are defined by our ethics rules. We're always bound by the law, of course. The ethics rules recognize our role as champions for our clients. And it's a very enjoyable role for me. But we have to recognize what it is. The fact that we represent people does not mean we agree with them. And we're supposed to leave the biases, obviously, aside when we represent people. I've represented people I don't like, and that's just the way it is. But journalists go about their role totally differently. And we as a society, America more than even Europe, expect our journalists to be fair and to be complete and to not withhold things. And when Dan Rather didn't do that, he was gone as an anchor man and gone as a professional, frankly. That would not harm a lawyer's professional life at all. We're going to talk about today is some other intersection, and that is what lawyers can say publicly about their cases. That is, when we go out to the public and use the media as lawyers, what limits are there when we do that? And what limits are there when we go to the media and talk about judges? What are the limits there? This is not some dry ethics rules. It may seem that way, but think what's going on now. I just saw, I was checking my emails, not surprisingly, and checking the news, and there's another article about George Zimmerman. He's wearing body armor, apparently, when he goes into the public and disguises. His lawyer has faced criticism for really a campaign of tweeting and social media statements about Zimmerman that folks are beginning to question whether he's poisoning the jury pool. And so we're going to see how that plays out. February 25th of this year, this is from Law 360, attorney defends Facebook posts dissing McDonald's settlement. A Michigan attorney demanded Friday that the state court overturn its order forcing him to delete Facebook posts criticizing a class action settlement with McDonald's Corporation over the allegedly false advertising of chicken products as pure in some Islamic Sharia law way. And this fellow was a McDonald's client, he and his family. And he said, I've got the First Amendment right as a lawyer to criticize this settlement. Now, he wasn't a lawyer in the case, but that's the intersection of First Amendment law and the right of a court to kind of control its docket and to prevent lawyers from speaking when the lawyers think that the judge think that they shouldn't speak. I'm going to come back to that when it comes to another famous Michigan lawyer. This is February 14th, 2013. February 14th this year, New York Law Journal, when prosecutors take liberties with the First Amendment. This is how it starts. Here's a juicy one. Jim Letton, the United States Attorney in New Orleans, was an aggressive prosecutor of corruption for the past 12 years. He has been the longest-serving federal prosecutor in a place where his talents were reportedly in need in New Orleans. That's careful journalism. What happened there is that there were some tweets and web postings about a local landfill magnet, one-time candidate for the position of U.S. Attorney named Fred Hebe. And some prosecutors were going after him. And there were various web postings that said things like this. He comes from a long line of corruptors, hardly the kind of thing that people should be electing. And asking questions about, don't you ever wonder how they get rich in public office? Not possible unless stealing. Well, Hebe suspected that there were actually lawyers in the U.S. Attorney's Office that were posting these things, and he was right. Their assistant U.S. attorneys who have since resigned were anonymously posting things, even though they clearly shouldn't be. We're going to talk about what prosecutors can say. And this article, February 14th of this year, said that these people were forced to resign. Near the end of the article, it talks about, and this is back in the old days, most of you were too young to remember this, John Gotti prosecution, Bruce Cutler. Remember Bruce Cutler? And I had lots of hair compared to Bruce Cutler, but he was given criminal contempt, sentenced to 3 years probation, 90-day house arrest, 180-day suspension from practicing in the Eastern District of New York, and 600 hours of community service for basically violating court orders about speaking in public. He was defending his clients in public, John Gotti in public. So he paid the price for it as well. And finally, this was last December, 27th of 2012, Wisconsin Supreme Court publicly reprimands a lawyer for violating the ethics rules on judicial criticism. I'm going to ask you to draw the line there, what lawyers can say about judges. This was a case where a lawyer actually was taking care of a disabled veteran. He and his wife were taking care of the disabled veteran and basically living off the disabled veteran's income. And the judge refused a guardianship for them and gave a guardianship to someone else. And the lawyer publicly blasted the judge, saying that the judge had acted with bias and prejudice, orchestrated a staged performance for the public to give the appearance of justice, and used the guardianship proceeding for his own political and personal agenda. And the court came after him. I'm going to ask you what the bars and the court should do about that. The lawyer did not dispute that he made the negative statements, but I'll read from this article that I just read recently. He asserted that his comments were protected by the First Amendment because they stemmed from his sincere belief that he was following God's will in pursuing guardianship of this person. So you cannot point to God's direction and avoid being sanctioned by the court. So I'm going to ask a series of hypotheticals. I'll ask, maybe demographically, the non-lawyers first, and then I'll ask the lawyers. So let me ask you this first. What limits, should there be any limits on what lawyers can say about their cases other than defamation, which prevents people from false and defamatory statements about somebody, and duties of confidentiality to our clients? We have enormous duties of confidentiality, so you can't even name your client in most states, can't even give the identity of your clients without the client's consent. So there's that duty. There's the defamation tort duty. There's court orders and so on. But beside those, should there be any ethics limits on what I say about cases? And of course, I can't lie about things either. So there's that limit. But apart from those limits, Should there be any limits on my speaking about my cases? Non-lawyers first. Should there be any limits at all on what a lawyer can ethically say about his or her cases? Limits? Who votes for limits? Yes? Got limits? Yes. How about no limits? Okay. First Amendment. Okay. So we got a mixed vote there. Let's say the lawyers. How about our future lawyers? Should there be limits? Yes. How about no limits? There shouldn't be any limits. Wow, we almost totally 50-50 on that one, too. Let me ask you a series of more specific questions. And these are the people that said there should be limits. Okay. So if you think there should be limits, let me ask you this. Unless we can combine the lawyers and non-lawyers. Should the limits apply to all lawyers or just lawyers involved in the litigation, for instance? So one is all lawyers and the other is just the lawyers involved in the case. Who thinks all lawyers? How about just the lawyers involved in the case? Okay. Should it apply only in criminal cases or criminal and civil? Who thinks just criminal cases? How about criminal and civil? Why, unanimous there. Should it apply only to jury trial cases? Only when there's a jury? Yes or no? Just jury? Yes? How about no? All right. Should it apply only to pending cases? In other words, or to apply to cases that are already over? Who thinks just pending cases? Yes? How about even if it's over, you can't talk about it? Oh, wow. Okay. All right. Well, let's go back then and see what. It should be obvious, but somebody articulate the competing interests that we have here. Ethics are all about competing interests. What are the competing interests here? They seem obvious, but somebody want to speak up and mention them? Maintain eye contact? Okay. Well, they're sort of obvious. One is the First Amendment and the interest in transparency about the justice system. We want there to be transparency. The public is benefited when people know about the trials and know about what's going on. Big debate in every state, including the Supreme Court, about TVs in the courtroom. You ever wonder why in Florida you get to see everything that goes on, even if you don't want to see it? And in most states you don't. In Virginia, we don't have cameras in the courtroom. It's a very conservative state. And there's been talk about having cameras in the U.S. Supreme Court for the health care argument. For instance, they didn't do it. The Supreme Court began to have audio recordings, but then released later. So a big debate about that. But everybody agrees that it's good for the society to have some transparency about the justice system. On the other hand, you can taint the jury pool. And that may be what George Zimmerman's lawyer is trying to do. So that's a real consideration as well. Let me give you the history of this. And I'll ask you, well, I guess I've already asked you, but the New York rules are quite different from the ABA model rules. Let me explain how the ethics rules work. The American Bar Association is reportedly the world's largest voluntary organization. It's hundreds of thousands of members, but it's a voluntary organization. It comes up with what they call model rules, that is, rules that they suggest that, that states follow, but no state follows them totally. Every state is somewhat different. Some states are totally different. The ABA will sometimes require disclosure when states will prohibit it, and sometimes will prohibit it when other states require disclosure. In this case, there's going to be some differences that I'll mention between New York and the ABA model rules. But and every state itself, I should have finished the story here, has its own ethics rules. And so those are the rules that guide us. I'm only licensed in Virginia, so my Virginia rules apply to me. If I come to New York and say something, the New York rules, Virginia in disciplining me might apply to the New York rules to my behavior. There's a choice of laws issue there. There were no limits on what lawyers could say until the 1960s. And there were two incidents that occurred in the 1960s that prompted the ABA to adopt limits. The first was, believe it or not, the Warren Commission looking into the assassination of President Kennedy. The ABA took a hint from the end of that. The end of the commission said, you guys got to do something about people going out speaking about people's guilt and innocence and so on. And then in 1966, the U.S. Supreme Court, in the famous case of Shepard versus Maxwell, found that pretrial publicity was so bad that somebody didn't get a fair trial. Very difficult to prove that, but it was met that standard in 1966. So in 1968, the ABA adopted its current model rule with one little tweak. This is what it says. A lawyer who is participating or has participated in the investigation or litigation of a matter So it's not all lawyers. It's the lawyers who are participating or has participated in the investigation or litigation of a matter. So it sounds like litigation, not all lawyers. Shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So that's the rule that the ABA adopted. Now, New York has a very different rule. New York does not mention investigation or litigation. So the New York rule simply says a lawyer who's participating in a matter. And so that could apply to any lawyer. And New York goes out of its way to say criminal or civil, although the ABA doesn't imply otherwise. New York makes it clear. So that's the standard. The ABA rules then go on to say, well, there's certain things that you can say, certain things that you can't say. And most of those deal with the criminal law, although it clearly applies in most states to criminal and civil law. In my state of Virginia, this rule applies only to criminal jury trials. So it's a very limited application in Virginia. So the answers are, and I'll give you some little bit of history too, but should it apply to all lawyers? No, it's just the lawyers that are involved in the matter. Now, there's other limits. I mean, I can't prejudice a jury that if I'm not involved in the case by lying, for instance. I've got to be honest in my dealings, but I'm not going to be bound by this rule. It applies to criminal and civil cases, and it applies to jury and non-jury matters. Now, that seems odd, doesn't it? Why do we care? If we're worried about tainting the jury, why would we apply it to non-jury cases? Don't we think a judge would be capable of ignoring a lawyer's statement about a case? Why do we think, would anyone explain why we apply it to non-jury cases? I would think a judge would be sufficiently sophisticated to say, I'm just going to ignore that. The juror may not be, though. Yes, Professor?
We're concerned about public confidence in the judicial system, and the appearance of a learned member of the bar criticizing or influencing or trying to get involved in a proceeding.
Yeah, exactly right. So it's not just the taint of the jury, it's the entire societal taint we're worried about. And that's going to come back when it comes to the judge things as well. There is a self-defense exception. That is, if somebody says something and you want to reply, you have the right to reply. And if you didn't start it, you can have a self-defense exception. In the materials that I guess we're making available, there aren't many cases out there on this rule. And not because lawyers don't talk, that's all they do, but it's because they go over the bounds only rarely. Ironically, in 2000, you'll see this in the materials, 2006, Rhode Island Attorney General was sanctioned for this by criticizing lead paint manufacturers as those who would spin the facts, those who would spin and twist the facts, which is weird. I mean, lawyers say stuff like that all the time, but they nailed the Rhode Island Attorney General. I've always thought because he was the only Rhode Island public official not already in jail. But he was nailed on this one. But most of the time it's in the criminal matter and not the civil matter. So let's turn to criminal. Let me ask you this. Let's go to prosecutors. Do you think prosecutors should be held to the same standard about not talking about their cases, or should they be held to a higher standard than defense lawyers? So the vote is either same standard or, well, it could be lower standard, I suppose, depending if you're a Republican. But my theory as a Republican is that if they weren't guilty, they wouldn't have been arrested. But luckily I'm not a criminal lawyer. But so who votes for same standard? Okay. Who votes for higher standard? Whoa. Okay. Why would there be a higher standard for prosecutors? Somebody want to explain that? Yes, sir.
The prosecutor is the one driving the case. He can spin it to the point that it's prejudiced against him before the defendant even has a chance to speak. First move advantage.
So is it a timing, a temporal consideration, or is it something more than the temporal consideration, you
A lot
think?
of it's temporal, I'd say. Just the media might talk to him first.
Yeah.
You see it on the news that night, the next morning, and by the time the opponent's counsel has a chance to speak, already half the town's assuming he's already guilty.
Gotcha. Okay, well, that's a good point. Temporal is a really good point because he's the initiator. Anybody, any other considerations? Yes, sir.
I would look at what the prosecutor represents. The prosecutor represents the people, so therefore any statement made by him would be a representation of society as a whole, while a defendant would be speaking, on behalf of his defendant and what maybe they think subjectively.
Yeah, good point. The prosecutor is speaking sort of as a society. In fact, in a lot of states, I don't know, do they do it here with the people? Is it the people versus? Yeah. That's a pretty good deal, isn't it, to call yourself the people? One of my partners does a trust and estates work, so Nick, you got to wake up and listen to this one. He also litigates stuff, and some money was left to the Crippled Children's Hospital. So he called himself representing crippled children. And so it was Crippled Children Exhibit 1, Crippled Children Exhibit 2, and he figured he couldn't lose with that sort of thing. So, and as it turns out, he won. So, yeah, if you can call yourself the people as opposed to the Commonwealth, as they do in Virginia, that's a good deal. There's another reason, though, and that is that when I told you what we do is to serve our clients and try to win, not at all costs, but within the ethics limits, that's what we do. Prosecutors have a totally different duty. Prosecutors are supposed to do justice. They are not supposed to win. They are driven by an entirely different goal. And I've never been involved in criminal law, but every prosecutor I talk to says that they understand that. Even if they could bring a case, if they don't think it's just, they will not bring it. And they're bound by rules, but they're also bound by that basic concept. And so there is a interesting application of other ethics rules to prosecutors. Let me mention, how about the duty? I've talked about the duty I don't have, I guess, to reveal bad evidence. Prosecutors have that duty, but it's a legal duty. It's Brady. The requirements, not constitutional, but there may even be constitutional requirements to give exonerating evidence. A lot of prosecutors are accused of not doing that. It went to the Supreme Court recently, again, out of New Orleans. What a surprise that is. The former state DA was accused of running an operation that did not disclose what it was supposed to disclose. And you're probably familiar with his son. The DA was Harry Connick. Harry Connick Jr. is the singer that you've heard of, but his dad got in trouble as the New Orleans state attorney doing that thing. Every state in the U.S. is dealing now with an ABA change, and let me ask you how you'd vote on this one. The ABA has adopted a model rule that would require prosecutors to disclose more than the law requires. They would require prosecutors years after a case is over to step forward if they know exonerating evidence and disclose it to appropriate court. Brady does not require that. So the question that every state has is, should the ethics rules require more than the law requires, or should it match the legal requirement? Let me see how you'd vote here. Who thinks the ethics rules should go beyond Brady? Who thinks they should match Brady? Okay. New York, I just read last night, they go beyond Brady. Looks like New York is one of the first states to have adopted this new concept of no matter when it comes up, you got to disclose it. Ohio has specifically rejected that and said, no, this is ridiculous. Let's make the ethics rules match the law. Then we've got one standard we can apply. So prosecutors are more limited. And to me, I think they should be more limited because their duty is to do justice. It's not to win. They do speak for the government. I had never thought of the temporal thing, but that's as well. So the ethics rules do require more. Now I'm going to give you two examples, though, because let me give you one example. I'm going to ask you some basic questions about it. This comes from July 24, 2007. The North Carolina bar disbarred a Durham district attorney. And the very first paragraph, now he did a number of bad things, this Durham district attorney, but the first paragraph of the disbarment order says this: by making statements to representatives of the news media, which I'm going to read to you, including but not limited to those, he made extrajudicial statements he knew or reasonably should have known would be disseminated by means of public communication and would have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter, in violation of the rule that I mentioned. Now let me read the statements. The information that I have does lead me to conclude that a rape did occur. He was talking about Duke lacrosse players. It was Nifong was his name. The circumstances of the rape indicated a deep racial motivation. I'm convinced there was a rape, yes, sir. I'm satisfied that she was sexually assaulted at this residence. Now, who thinks that is an ethics violation for the prosecutor to say very clearly there's been a criminal conduct? Does anyone disagree with that? Okay. Does it matter that the Duke lacrosse players ended up being innocent? In other words, would it be the same rule even if they were guilty? Yes or no? Yes? Does anyone disagree with that? Okay. You were slow to put your hand down. You still disagree with it?
Yeah,
Yeah.
I think it should be the same rule.
Yeah, okay. Let me read something that another, this is a United States attorney, said in December 9, 2008. I'm going to ask you the same questions. This is a sad day for government. It's a very sad day for Illinois Governor Blagojevich. Blagojevich has taken us to a truly new low. Governor Blagojevich has been arrested in the middle of what could only be described as a political corruption crime spree. We acted to stop that crime spree. The conduct that he engaged in would make Lincoln roll over in his grave. That was U.S. Attorney Patrick Fitzgerald. Who thinks that's an ethics violation? Okay, I forced you to do that one. Does anyone disagree with that? Who thinks it doesn't matter that Blagojevich was guilty? Okay. Have you ever heard anyone say that Fitzgerald, who's the toast of the town, committed an ethics violation? As far as I know, the only person that wrote that was me in an article, which explains why I have to wear disguise when I land at O'Hare. It's very troubling to me as a lawyer, frankly, that prosecutors do that and get away with it. When he said that, it was on, did you all remember those lines? Yeah, they were front page news, and they were on the evening news. Everyone ran it. The Lincoln rolled over in his grave is a line that everybody carried. And yet it was as clear an ethics violation as Nifong did in Durham. And Nifong lost his license for that. The fact that Fitzgerald, to me, is the toast of the town is worrisome. I see prosecutors, and you will start seeing them now, making statements like that to me seem wrong. And that's just my opinion. I think prosecutors have to be very careful. The power of the state is awesome, but they're not. And the bars will often forgive statements like that. I never heard a hint of anyone even looking into those statements. And Blagojevich, the fact that he was guilty and deserved to go to jail, like you said, and I agree, does not make a difference. Okay, let's move to a different set of ethics issues here. This is a question of what lawyers can say about judges. Should lawyers, first basic question, let me ask non-lawyers first. Should there be any limits on lawyers criticizing judges? So should there be limits, yes or no, on lawyers' criticism of judges? Yes, should be limits? How about no, First Amendment right? Wow, okay. How about the lawyers? Who thinks, among the lawyers, who think there should be limits on criticism of judges? How about no, there shouldn't be any? Okay, yeah, you get 2 votes, which is good. Yeah, speaking of Chicago. Yeah, okay. Well, let me see if I can explain this one, because it'll become clear why I'm asking it. There's 2 kinds of limits that there could be. One limit would be on the substance of it, and one limit would be on the choice of words. In other words, are we going to look at the ugliness of the adjectives, and we say yes or no based on that? Or are we going to look at the really substance of the criticism? That is, look at the factual accusations. Who votes, for those of you who want limits, and if you change your vote, that's fine, who, just as a group, who thinks that it should be based on the words that are used? Got a couple words used, okay. Who thinks it should be based on the substance, the merits, the factual statements? Okay, most of the people vote for that, okay. Should it apply to a lawyer who is a talk show host and has his or her own talk show and criticizing judges? Same standards, or does the First Amendment protect that? Who thinks same standards? Who thinks First Amendment protects that one? Okay, we'll see about that. That went to the Michigan Supreme Court. Okay, let me read this and let me maintain eye contact here. Okay. I'm going to read the ABA Model Rule Standard, and I'll read the New York one, which is different. This is a good lesson for all the law students here. Don't take the ABA Model Rules. And somebody shout out when you recognize this standard, okay? A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, a adjudicatory officer, a public legal officer, or a candidate. What standard is that? It's New York Times constitutional malice, the defamation standard. Knowledge of falsity or reckless disregard as to its truth or falsity. So it's got to be either false, knowingly false, or reckless disregard, which in the defamation world is substantial awareness of probable falsity. It is not negligence, it's not gross negligence, it's beyond that. Now, New York law is different, which is, I didn't realize this till last night. In New York, it says a lawyer shall not knowingly make a false statement of fact. There is no reference to reckless disregard in the New York rules, which is astounding to me. So it's got to be knowledge. You've got to knowingly make a false statement of fact. Now, the defamation rules, as you know, one of the great ironies of defamation law is that the uglier the words that are used, the more likely it is to be totally immune from liability, because it's going to be an opinion. And so who thinks that if you say something ugly about a judge, you can use the opinion defense that's available in defamation, which has the same standard? So if I call this judge a brainless neo-Nazi coward, that's rhetorical hyperbole, but who thinks I am totally good to go because I can rely on the opinion defense? I mean, I want to appear that court again, but who thinks that is, who thinks it's immune from ethical challenge, from disciplinary process? Immune? Okay. How about no? Of course not. So you're starting to look at the words that are used, huh? I thought you voted against that most of you voted against that last time. Okay. Well, let me give you some examples, because the courts are split on this. District of Arizona, a former Greenberg-Trorig associate representing himself filed a pleading before Judge Susan Bolton, District Court of Arizona. Those of you who are lawyers already know this. On the right-hand side of many pleadings, you put assigned to the honorable. He has this assigned to the dishonorable, Susan R. Bolton. And this is what he says. This is the former Greenberg-Trorig lawyer. Judge Bolton, I just read your order, and am very disappointed in the fact that a brainless coward like you is a federal judge. Then at the end, he says this, finally, to Susan Bolton, we shall meet again, you know where. But he followed it with a smiley face. And so it came up in a number of ways. First, he was approached by the FBI for threatening a federal judge. But it came up on disciplinary charges. And the court said it was rhetorical hyperbole, incapable of being proven true or false. And so his motion is not sanctionable for impugning the integrity without proof of falsity. And you can't prove whether somebody's a brainless coward. Some other courts take that approach. District of Colorado. Such statements are pure opinion, calling a judge a racist and a bigot. Ninth Circuit. Someone said the judge was an ignorant, ill-tempered buffoon, a substandard human, right-wing fanatic, a bully, and one of the worst judges in the United States. No discipline for that, because it's not a provable statement of fact. Most courts take the other approach. Florida Supreme Court, 2001, we conclude that a purely subjective New York Times standard is inappropriate in attorney disciplinary actions. Ethics rules that prohibit attorneys from making statements impugning the integrity of judges are not to protect judges from unpleasant or unsavory criticism. Rather, such rules are designed to preserve public confidence in the fairness and impartiality of our system of justice, exactly like the professor mentioned. And most of the courts take that approach. In other words, that they will apply an objective standard, not a subjective standard. So, and I don't know why the bar adopted a New York Times malice standard. I have no idea of that. What the bar should have looked at was the ugliness of the words that are used. But the bar adopted New York Times malice, and therefore the disciplinary authorities have to go to the court and say, we really don't want it applied like the New York Times malice standard. This came up in New York. In fact, an Albany lawyer, May last year. An upstate appellate panel has censured Albany County DA, P. David Soros, for his reckless and misleading criticism. The DA released a following statement: Judge Herrick's decision is a get-out-of-jail-free card for every criminal defendant in New York. And he was criticized for that. Some other surprising criticism. There's a fellow that was the head of the appellate division at the largest law firm in Indiana. And he wrote as local counsel. He signed as local counsel, which means a counsel hired on the ground with some other national law firm doing all the work, but the local counsel would get to bill, so it's like a win-win. He wrote a brief with this footnote. The opinion is so factually and legally inaccurate that one is left to wonder whether the Court of Appeals was determined to find for Appellee Sports, Inc., and then said whatever was necessary to reach that conclusion, regardless of whether the facts or the law supported its decision. And he was suspended for 30 days for that criticism. most lawyers are much uglier in their writing. His real defense was, I didn't even read it, I'm sure, because local counsel are supposed to read it. He couldn't make that defense, but that's probably what he would say if he were honest. It's like I wasn't going to use the drugs, I was just going to sell them defense, which doesn't work really well in other cases. There's a case, I actually got to meet this judge, a wonderful judge, Laurel Meyerson Issakoff, Southern District of Florida bankruptcy judge. This was a statement in 2007 by the former head of one of the large law firms. I can't think what it was in Chicago. He was the head at that time, McDermott, Will and Emery, of the bankruptcy section. Not anymore. This is what he said: "I suggest, with respect, Your Honor, that you're a few French fries short of a Happy Meal in terms of what's likely to take place here." That didn't go over real well with Judge Issakoff. Let me talk about Jeffrey Feiger. Do you all remember Jeffrey Feiger? He's Kevorkian's lawyer. He had a talk show. He's a talk show host. And he got into a tussle with judges in the Michigan court system. And I'll tell you about the ups and downs of that one. August 23rd, 1999, he has a talk show. He's talking about a case that was dismissed. It was a personal injury case that he won, and then it was appealed and it was reversed. And this is what he talks about: the 3 Court of Appeals judges in Michigan. "Hey, Michael, Talbot, and Banstra and Markey, I declare war on you. You declare it on me. I declare it on you. Kiss my," you can guess that. Okay. Somebody said, "Are you using innuendo about those judges?" And he said, "The only thing that's in their endo should be a large plunger the size of my fist." Now, he had the misfortune of calling another Court of Appeals judge remarkably stupid. And it was misfortune because that judge later became Michigan's Chief Justice. So his punishment, he's punished by the bar for those statements, and it goes to the Michigan Supreme Court. Now, who thinks that he has the First Amendment right as a talk show host to make statements like that? In other words, could he be punished by the bar for making those statements? Yes or no? Can be punished? How about no? He shouldn't be punished for that. Okay, so we're almost 50-50 split. Ironically, the Michigan court was 4-3 in favor of upholding the punishment, 76-page opinion. And the dissenting judges said, Justice Weaver, among others, said, how can you, Chief Justice Taylor, sit on this case? He called you remarkably or amazingly stupid. And so the majority, the 4-3 majority judge, now think about this is a 76-page opinion on how you're not supposed to say ugly things about other people. The majority says this, that Justice Weaver, they name her, was motivated by a personal resentment and her personal agenda that would lead to nonsensical results affecting every judge in Michigan and throwing the justice system into chaos. This is in the majority opinion about the dissenting judge. It is deeply troubling that a member of this court would undertake so gratuitously and so falsely to impugn her colleagues. This is a sad day in this court's history, for Justice Weaver inflicts damage not only on her colleagues, but also on this court as an institution. Now, wouldn't that be fun to go to lunch after that with all the judges? So they uphold it, but that's not the end of the story. The Eastern District of Michigan Federal Court finds that the ethics rules under which he's punished were unconstitutional, but the Sixth Circuit reverses. And then Feiger is indicted for funneling money to the Edwards campaign. Remember, he had all of his people at the law firm gave amount of money to the Edwards campaign, and then they all received bonuses of the exact same amount. And that was a really good investment for him. But so the question, he's going to trial, and his law firm runs ads that describes the Bush administration to Nazi Germany. And the prosecutors moved to enjoin the ads. Now, let me ask you this. This is like the gift that keeps on giving for First Amendment stuff. Who thinks that the judge, that the court enjoins the law firm's ads? Enjoins the law firm's ads, yes? How about no? They do, which is surprising to me. I would have voted no. I was really surprised. The court finds these two commercials are unequivocally directed at polluting the potential jury, venire, in the instant case, in favor of defendant Feiger and against the government, which is remarkably surprising to me, frankly. So we've got tea time. Okay. Anyway, some judges are criticized not by lawyers that are appearing before him, but let me read this one and see if this is the kind of thing that should be punished. Remember the judge, well, you probably don't remember the judge, remember the incident where Brian Nichols grabbed a gun in an Atlanta courthouse elevator, I guess, shot people, and then escaped from like a 10-story building. I don't know how you can not stop somebody from escaping from the courthouse in Atlanta. And then he ran away. He was hiding in somebody's house, and she prayed with him, and he surrendered. Remember Brian Nichols? The judge handling the case is Judge Fuller. And Judge Fuller gave an interview with a magazine and said it's going to be hard to try this case, that is the trial for what Nichols did, because the whole world knows he did it. So here's the judge having said that. And somebody writes this: is there any way to replace the embarrassment Judge Fuller is? He is a disgrace and pulling all of us down. He is single-handedly destroying the bench in indigent defense and eroding the public trust in the judiciary. See his latest order. He cannot tell the legislature what to do. Enough is enough. Enough. He is a fool. How is it done? Seek mandamus for a trial? We should investigate it if it can be done. Who thinks that should be punishable? That's ugly language. Punishable? Yes? How about no? Okay, well, you may have heard it. This was one of his fellow judges that said this. It didn't get a lot of press at the time, but it finally came out, and it was embarrassing. Judge Fuller actually eventually did recuse himself. He said, having said that, I can't really try the case, but it took some pressure to get him off. So let me ask you, I'm going to give you a series of statements that you might make about a judge, and I'm going to ask you whether it's ethically permissible to say these things. We respectfully disagree with the judge's recent decision. That's okay. Yeah, absolutely. We think the judge got it wrong. Yeah, okay. We think the judge totally missed both the facts and the law presented at the trial. Yes? Does anyone vote no for that one? Are we getting any no's? Okay, yeah, we got one of these going. Okay, all right. We were astounded at the judge's lack of understanding of basic legal principles. Okay? How about, no, you can't say that. We're getting no votes now. We obviously disagree with the judge's stupid decision. Oh, you think that's okay?
I'm going to keep my hand. Is it allowed or should it be okay? It's two different things. I think
Okay, yeah. But now notice, those all say the same thing, don't they? They say it in slightly different ways. But going back to my question, which all of you voted the other way on, should it depend on the words that are used or on the substance? And to me, the rule should be based on the words. I know that doesn't make a lot of sense maybe when you think about it in the abstract, but I think it makes more sense to limit the emotional impact of the words rather than the intellectual content of them. And yet, the rule that we've adopted, the reason I want to talk about this rule is that the rule that every bar is adopted is ridiculous. It's nonsense because it would immunize the very words that you want to stop, because it immunizes opinion, and it only applies to statements of fact and knowingly false statements of fact. And so if some person says, I really think the judge is on the take, I really think the judge is getting money, that would be a defense in a defamation case, because how do you prove knowledge of falsity? He really believes it, or she really believes it, and yet we can't live with a statement. We can't live with a rule like that. And one of the reasons we can't live with a rule like that is that the judges cannot defend themselves. At McGuire Woods, we were called upon years ago to come to the rescue of a wonderful judge, Judge Robert R. Marriage, who integrated the Richmond schools and had his garage burned down. Somebody shot his dog. He was one of the heroes of the Southern Judiciary, and a really good guy as well. He was accused of improper behavior by some criminal defendant from North Carolina who said that the judge was on the take or acting improperly. And the two largest law firms in Richmond came to his rescue because he couldn't speak. He could not really defend himself because of the limits on judicial speech, which I'll get to in a minute here. And so we went through the whole record. I was one of the very young lawyers and didn't find anything wrong. We issued a white paper, and that was the end of it. So it's important for judges, if they can't defend themselves, to be defended by the bar. It's also important for us as lawyers to not criticize judges in a way that inflames the public, getting back to the whole public affair, not just to save them from their tender feelings. It's really an institutional, societal, systemic concern that we have. Okay, I've got a few more minutes. Let me just close with a discussion of judges' communication about their cases. A judge shall not make any public comment that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court, or make any non-public comment that might substantially interfere with a fair trial or hearing. So it's unlike lawyers. The lawyers, the limit is on things that are going to be in the public eye and the public media, reasonably believed to be public disseminated. There's two standards. Let me read it again. This is the ABA Model Code for judges. A judge shall not make any public comment that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court, or make any non-public comment, that's at a cocktail party kind of way, that might substantially interfere with a fair trial or hearing. So there's two levels for judges, depending on whether it's public or non-public. And some of the other, like the federal bar, the federal judges code, takes a very different attitude. So judges cannot talk about their cases. They can't talk about other judges' cases. There was a case in New Jersey of a judge where the judge wanted to be a comedian. We were just talking about that today. He was told he couldn't be a comedian. Judges have to be careful. That may be kind of a respect for the office kind of decision. But a judge in New Jersey wanted to talk about the O.J. Simpson trial, was told, no, you can't talk about the O.J. trial, Judge Ito or anything, because even though it's not pending in your court, it's pending in some court. And so judges, even though we want them to be part of society, have to be very careful what they say. They can talk about the administration of justice, and that's really it. Judges even have to be careful in their personal communications. I wrote an opinion from the Judicial Ethics Advisory Committee, the drafter of an opinion in Virginia, on what a judge can do with letters of recommendation. The judge cannot use official letterhead. The judges cannot say to whom it may concern. It has to be focused. The judge has to disclaim any professional or any sort of judicial endorsement. It has to be personal. And so there's real limits on judges. The worry there is that people will feel pressured by judges, and therefore we will restrict our judges from making even letters of recommendation. So if you're looking for a judge to get you a job or something, you have to be really careful how you do that. They can't talk about public policy issues either. I'm going to close with something that's astounding when you think about it. I'm going to ask you if you know the meaning of a word. Let me ask you this first. Who knows what the word paralipsis means? Paralipsis. It's a word you want to know. A paralipsis means mentioning something by saying you're not going to mention it. And that's to say, I'm not even going to mention her drinking problem. That's called a paralipsis. One of the former professors at Yale Law School, now in the Second Circuit, Guido Calabrese, former dean of Yale Law School, said this at a meeting of the American Constitutional Society. Okay, I'm a judge, and so I'm not allowed to talk about politics. And so I'm not going to talk about, this is during the Bush administration, getting back to the Iraq War. I'm not even going to talk about some of the issues which were mentioned, which is, among other things, the extraordinary record of incompetence of this administration at any number of levels. So I'm not going to talk about that. That's a paralipsis. Okay, I am going to talk about a deeper structural issue. Somebody came to power as the result of an illegitimate act of a legitimate institution. That is what the Supreme Court did in Bush versus Gore, put somebody in power. Now, I might have won anyway, but the reason I emphasize that is because that is exactly what happened when Mussolini was put in by the King of Italy. Who wants to guess what happens, what he says next? That's what happened when Hindenburg put Hitler in. And so somebody said, well, you're comparing the President of the United States to Adolf Hitler. Judges aren't supposed to do that. 5 days later, he apologized, and he said this: as you know, I strongly deplore the politicization of the judiciary and firmly believe that judges should not publicly support candidates or take political stands. No, I actually didn't know that. Okay. Although what I was trying to do was to make a rather complicated academic argument about the nature of re-elections. That is not the way my words understandably have been taken. And the Second Circuit Judicial Council did not find that they were a per se violation, which is amazing to me. They found that they violated the prohibition on judges' involvement in political activity, did not pose any punishment given the judge's apology. But at the same time, the Associated Press, they dealt with an Associated Press story that Mrs. Calabrese was protesting at Yale University, and this is what the AP said, getting back to the press. The AP reporter said Mrs. Calabrese was, quote, protesting on behalf of herself and her husband, identifying him by title, court, and name, and that she expressed anger about the president's veracity and conduct of the war. And the Judicial Council pointed to the letter from Mrs. Calabrese that she had no recollection of saying that to the AP reporter. So they dismissed the complaint against him for what she said. So judges sometimes wander into the world of media. They're not supposed to. The Supreme Court judges do more than most because they're not bound by the ethics rules, not surprisingly. But generally, judges have to keep their mouth shut, and that's hard for judges because they're formerly lawyers, and we hardly ever keep our mouths shut. But as a result of that, we as lawyers, and when you join the bar, you'll have to do this as well, have to come to their rescue when judges are unfairly impugned, because otherwise the system suffers. As the professor said, all of society suffers if we don't trust our judges, and so we all have to defend them. Okay, we've got 1 minute, the food's here, but I'm happy to take questions if there are any questions. I appreciate people participating along the way, and I really appreciate the invitation. Thank you.